Good evening. I'd like to start with a simple question. Imagine someone tells you that they're so angry that they want to hurt another person. They think about it for days and maybe even imagine exactly how they would do it. Should they be arrested just because they have those thoughts? Most of us would probably say no, but as disturbing as those thoughts may be, simply thinking about committing a crime isn't enough to make someone criminally reliable. According to Chapter 3, the law requires more than bad thoughts or bad intentions before somebody can be convicted of a crime. There must be a criminal act. That criminal act is called Actus Reus, which is Latin for evil act. It's one of the most basic building blocks of criminal reliability, along with mens rea and concurrence. At first, Actus Reus sounds like a complicated legal term, but the idea behind it is actually pretty simple. The law punishes what people do, not just what they think. A person may intend to commit a crime, but unless that intention is connected to some kind of criminal action, there's generally no crime. Chapter 3 uses the example of someone pulling the trigger of a gun. Pulling the trigger is the actus reus because it is a physical act that turns intention into criminal conduct. One thing that surprised me while reading this chapter is that not every criminal act has to involve dramatic physical violence. Sometimes the required act can be something as small as saying a few words. For example, the textbook explains that crimes such as solicitation can be completed through speech alone. The important point is that there must be some type of voluntary action that the law recognizes as criminal. That brings us to one of the biggest ideas in the section, which is voluntary acts. In general, criminal reliability requires that a person's actions be voluntary. In other words, the person must have control over what they were doing. If someone's body moves without any control, like any certain medical emergencies, then those actions may not satisfy the Actus Reus requirement because they weren't truly voluntary. The chapter gives an interesting example to show why this matters. Imagine someone lights a cigarette, accidentally falls asleep, and then the cigarette just starts a huge fire and it unfortunately kills another person. Now, if you compare that to someone that intentionally pours gasoline around a room, lights a cigarette, and then deliberately just starts the fire, then in both situations, lighting the cigarette was technically voluntary, but the law treats those two situations very differently. One was accidental, and the other one was very intentional. This example shows that Actus Reus isn't just about movement. It also helps us understand that the circumstances around the movement. The textbook also discusses the case People versus DeSena, which raises an important question about voluntary conduct. In that case, the defendant suffered from epilepsy but chose to drive anyway. While driving, he experienced a seizure, lost control of his vehicle, and struck several children. At first, someone might argue that the crash itself wasn't voluntary since he wasn't conscious during the seizure. However, the court focused on his earlier decision to get behind the wheel, knowing that he had a condition that could cause him to lose consciousness. That choice was considered voluntary and became the basis for criminal liability. I think this case really shows why Actus Reus can be more complicated than simply asking whether someone moved. Sometimes courts have to look at the entire sequence of events to determine where the voluntary act actually occurred. Another interesting point the chapter makes was that the law usually doesn't punish a person's status. The textbook discusses a Supreme Court case involving drug addiction where the court ruled that Simply being addicted to narcotics could not be a crime itself, but the law can punish illegal actions like possessing or selling drugs, but not someone's condition alone. Once again, the focus really stays on conduct rather than the status or the thoughts. Another part that I found interesting was sometimes a crime can involve in not doing something. Normally, the law doesn't require people to step in every time someone else is in danger. Just because someone thinks that they should help doesn't mean they're legally required to help. But Chapter 3 explains that there are certain situations where failing to act can be a criminal act. These are called omissions. Omissions can lead to criminal liability when a person has a legal duty to act and they choose not to. The textbook explains that these legal duties usually come from specific relationships or responsibilities. For example, parents have a legal duty to care for their children. Caregivers have duties for those that they're responsible for. Sometimes it can come from a contract or even from creating a dangerous situation in the first place. If someone ignores one of these legal responsibilities, then another person is harmed, then that failure to step in can satisfy the Actus Reus requirement. One thing that I appreciate about this section is that the law doesn't expect people to be heroes, but they focus on whether someone had a legal obligation that they should have done something. That creates a balance between encouraging people to help others while also recognizing that not every moral responsibility is a legal one. The chapter also mentions that some states have adopted bad Samaritan laws, but in most situations, there's still no general legal duty to rescue a stranger. Lastly, I would like to talk about possession because I didn't think it would be under criminal law. I thought it was strange. Like, how can having something simply be an act, but possession is treated as Actus Reus because a person knowingly exercises control over an object. The chapter breaks possession into two types: actual possession and constructive possession. Actual possession is easier to understand because that means the object is physically on the person, like having drugs like in your pocket or a stolen item in your bag. But constructive possession is a bit different. It's just because the object isn't physically in your hands, but you still have the ability and the intent to control it. Like if illegal drugs are hidden inside your locker or the trunk of your car, you could still be said that you are in possession of them because you have control over their location. Learning about these different forms of possessions helped me realize that criminal law are often more detailed than it appears. It's not really enough to ask whether simply touched an object because courts look at whether the person knew it was there or whether they had control over it. Those details can completely change the outcome of a case. After reading Chapter 3, I realized that Actus Reus is much more than just the criminal act. It represents the idea that the law punishes conduct, not just thoughts, feelings, or personal status. Whether the issue involves a voluntary action, failing to perform the legal duty, or possessing illegal property, there has to be some type of legally recognized act before someone can be legally held responsible. Thank you.